We start with a case that is a statistical tie with Mr. Franken ahead by 225 votes. There have been mistakes. I'm not attacking the Minnesota system as a whole, but even Mr. Franken's side have found 160 mistakes that they want this court to open and count. Our case consists of three sections. First is our allegation that either 132 or 133 ballots in Minneapolis 3-1 cannot be added to the recount, and neither can approximately 35 to 40 others that contestee has brought up. Second, that when all the physical ballots that were counted on election night were present, they should be recounted. Hence, the duplicates, both marked and unmarked, should be counted. These will equal election night totals, not because we want to revert to a machine count, but because they're the most accurate count. Third, that our approximately 1,350 ballots set forth on our spreadsheet are presently disenfranchised, honest Minnesota voters who should have their ballots counted. Simply put, because we've sufficiently proved their legitimacy by a preponderance of the evidence, which is an issue that neither Mr. Hamilton nor this court has ever directed itself to from the beginning of this trial. Overlaying these three specific areas is our claim that Minnesota voters who were alive on election day signed the ballot envelope with their genuine signature, had a witness with a Minnesota address, had voted within the last 4 years, or registered on election day with a VRA, and sent in an application, should be enfranchised. From a philosophical standpoint, we don't try to keep voters from having their vote counted. We try to enfranchise as many as possible, and I don't think that could be clearer from the way that I cross-examined the voters called by the contestee, if you could call it cross-examination, because it would be disingenuous for us to take the position that any of those people called by the contestee should not have their vote counted. Of course they should, and so should a lot of others. Let me go in reverse order to the way that contestee presented the defense. I'd like to deal first with the so-called issue of 132 or 133 in Minneapolis Precinct 3-1. The net result, if those 132 or 133 or however many there were votes are not counted, it results in a reduction in Mr. Franken's lead of 44 votes. When all else fails, as I addressed during my argument in relation to the invalidity of Secretary of State's Rule 9, when all else fails, turn to the law. In 2008, statute was amended, 204C.35, which talks about recounts. And it was amended in the following way. The word manually was inserted into the statute in two places for the first time. The legislature, after reflecting on the issue, determined that a recount needed to be manual, Manual means by hand. In fact, that's been the situation for some time, but the legislature made it clear in 2008. If you add that insertion into the statute, let's talk about the issue of chain of custody. We heard testimony, witness after witness, how careful they are, how careful the officials are to protect the chain of custody of ballots. We put them in transport cases. We seal them. We initial the seals. We protect the chain of custody of ballots in this state, and I suspect every other state, as carefully, if not more so, than we protect the chain of custody on drug evidence or blood evidence. The ballots are guarded, they're sealed, they're transported, secured, they're surveilled. Both sides have the ability to watch them 24 hours a day if they so choose. Why do we do that? There's only one reason: to protect their integrity so that they can be, according to the statute, manually recounted. Why else would we care about the chain of custody of ballots? They're not going to destroy each other. They're not going to devour each other. The only reason the chain of custody matters is so that they can be preserved for a recount. And if they're missing for some time and then they reappear somehow, you would hear all kinds of objections to counting them. Minneapolis 3-1, and the unknown number of ballots in that envelope, by Ms. Reichert's own testimony, the envelope disappeared, there were some ballots in there. This is the ultimate chain of custody problem. The chain of custody was broken for all time. The ballots are missing. They cannot be found. We don't know their number. We know there were a group of them. In fact, I carefully examined Ms. Reichert to show how carefully they were watched and what their procedures were. That was to demonstrate to this court how important the chain of custody is. And if we had a group of ballots that were gone for 2 hours somewhere mystically and then picked up 2 hours later by accident, there'd be terrible objections to counting those ballots. So how can we count ballots that are gone forever, apparently? And I take Ms. Reichert and Mr. Gelbman at their word that everything that could be done was done to find them. In 1880, in Newton against Newell, 6 Northwestern 346, which might be the oldest case I ever looked at in my life, the court said if they're lost, they can't be counted. And I would also mention the Moon case that's about 40 years later that Mr. Hamilton mentioned. First of all, there weren't any machines back then in 1920. So it hadn't got anything to do with this. And in the Moon case, 2 precincts lost all the ballots. So they went by their first count, which happened to have been manual. In 2008, the legislature inserted the word manually. They didn't do it for no reason. We sometimes criticize why legislatures do things, but they always have reasons. And here you have the ultimate chain of custody issue. The ballots are lost. The side wanting the recount is entitled to have them counted. If they can't be counted, there's only one thing to do, and that's disregard them. Recount comes with some privileges: the interpretation of voter intent, which can't be done, the question of ballots that may look suspicious, but just the fact that the contestant had the right to have them counted, they're gone and they can't be, and the law is clear. Which raises what I think is a collateral issue that I was asked, that I assume was simmering below the surface for a while, and that is, the canvassing board has 2 Supreme Court justices on it. Can we overrule them? Well, there isn't an overrule situation here. The canvassing board has ministerial duties only. This issue was left to you. Their decision has no impact here. This is a de novo court, and when you can't count them in person, you can't count them at all. Let me go to the duplicate and original issue. And here, there is a 61 vote swing in favor of Mr. Coleman, and I may have worn this issue out the other day in arguing concerning our position that Rule 9 set forth by the Secretary of State is invalid, it violates the law, and it can't be enforced. But let me quickly go over the issue again. What was counted on Election Day in relation to the dupe and original issue is here. They're present. They can be counted again, and the count will match the machine or come much closer than it does at the moment, because the evidence is that there were unmarked duplicates run through the tabulators. How do we know that? First of all, when the candidates started talking about, or I suppose the campaigns is more accurate, what to do about original and duplicate issues, all of the people involved professionally were nothing less than horrified. There were emails sent to the Secretary of State. Are you sure you want to do this? This looks bad. And then nobody will forget the comment with about 15 G's and H's in it from one of the county auditors saying, and what is it they were afraid of? They were all afraid of the same thing, that what you're going to end up with here is duplicate counting. You're going to end up with double counting. You're going to end up with more votes than voters, which happened in a number of precincts, although we only present 10 for your consideration. What was the Secretary of State afraid of? Well, you had Mr. Gelbman, and you had Mr. Poser here. They opposed this. In fact, Mr. Poser, in essentially apologizing to a county auditor, said, I lost this battle. Well, what happened, as I referred to the other day, is the campaigns got together and obviated the law, which they had no right to do, because that law is there for the protection of the voters, not the candidates. 2 candidates cannot get together and do away with a statute designed for the protection of the voters, no matter how wrong they may think it is. Not only that, I'm going to make hopefully short shrift of the argument here that there's some kind of estoppel, because for estoppel there has to be reliance, and for reliance there has to be prejudice. In this situation, those duplicates that went through the machine are still available, they're intact, we can go back, we can count them in 10 precincts, and you're going to come up with a number that doesn't signify more votes than voters. It's an easy remedy. I believe the estimate was that it'll take between 1 and 2 hours per precinct to do that. In order to follow the law, that's not a big sacrifice of time. In addition, as I mentioned before, the only thing the campaigns were thinking of when they formulated that rule was that the originals are the best evidence of voter intent. They weren't thinking of ending up with more votes than voters. Neither side was, and nobody would propound that proposition to you that I had in mind. I wanted to get more votes than voters. What they wanted to do is have clear evidence of voter intent if there were challenges on some ballots. What happened was the election judges take care of that problem when they make the duplicate. The election judges evaluate voter intent when they copy. And they're from competing political parties. They reach a conclusion as to what the voter's intent was, and if they have a problem, there's a chief judge to help them. So the duplicates are the manifestation of voter intent. The originals are kept sequestered in an envelope. The law says you count the ones that went through the tabulator, which are the duplicates marked or unmarked. Now let me go to another issue. And that's the issue of to what standard is it required that a litigant in this contest prove the validity of a ballot that's unopened? With all due respect, the standard that you've set requires proving each statutory element to an absolute certainty. That standard doesn't exist anywhere in Anglo-American jurisprudence. Our job is to prove up ballots for counting. We believe and have urged that Minnesota is a substantial compliance state. You've ruled that based on your February 13th order that you demand strict compliance going forward. So be it. We'll concede that arguendo at this point. And so strict compliance with the statute under your February 13th order is required. But where is it written that we must prove compliance with that statute to a certainty? That's what you have apparently demanded of us. With all due respect, that holding was created out of whole cloth, and it just growed like topsy. In fact, as I recall at one point, and I don't believe this ever became the standard, Judge Riley took the position that in order to prove that a voter didn't vote elsewhere, we had to prove they didn't vote anywhere in any other county in the state. That's virtually incapable of proof. So we take issue with the standard. This is a civil case. The burden of proof is by a preponderance of the evidence. And absent some statutory pronouncement to the contrary, that's the standard that we are required to fulfill. Contestee has chosen a different path. They have proved the viability of a number of ballots to an absolute certainty, to where there can be no conceivable question, but that most of the ballots they've put in issue should be open and counted. We congratulate them for their dedication to precision, and they're meeting the standard of moral certainty. That's a commendable thing. But that standard exists nowhere else in Anglo-American jurisprudence. All we need to prove under your strict compliance standard is that it is more likely than not that inside the envelope dwells the franchise of a proper voter. More likely than not. One who is more likely to have conformed his conduct to the ingredients of the statute than to have done the opposite. That statute we accept your ruling for the purposes of this argument, requires strict compliance. Let me illustrate. Ms. Reichert, I'm sure not intending to, makes our case for us. It lies in her answer to a series of questions concerning witness registration. She, and at her direction, the workers in the city of Minneapolis, check for witness registration when the witness gives an out-of-state address. Why do they do that? Because it's more likely than not that people who live outside the state are not registered Minnesota voters. It's a very, very sane process. Why would you make an assumption that somebody that lives in Massachusetts is registered to vote in Minnesota? You wouldn't make that assumption. What you would do is find out, and that's what they do in Minneapolis. Now, what does she do when there is a Minnesota person who is the witness? She makes the assumption they are registered, and so does the entire city of Minneapolis, and in fact, all but 4 or 5 counties in the state make the assumption that the law was followed and that a person with a good Minnesota address is a registered Minnesota voter. Why do they do that? They do it because they presume that our citizens will follow the law, which for the most part is correct. Now, we know something in this case. We know that based on the evidence, if you check on witness registration diligently, prime example, Carver County, you will find about 4% of the witnesses are unregistered. Carver County is very, very careful, probably the most careful, because out of 4,800 ballots, they found 180 with unregistered witnesses that they kicked out. 4% unregistered. That means 96% of the people with Minnesota addresses who signed as witnesses are registered Minnesota voters. 96%. Which means that when you look at a ballot envelope with a Minnesota address person on it, the chances are 96% that they are registered. That's more likely than not. It's more than probable cause. It's more than clear and convincing. And based on experience, it's also more than proof beyond a reasonable doubt. It's proof beyond a moral certainty. You make presumptions as you go through life, and you make presumptions based on experience. If 96% of the witnesses on the front of the ballot are registered Minnesota voters, and we know they are based on the Carver County experience, then it is presumptive, beyond peradventure, that you're going to be right 96% of the time. So when Ms. Reichert tells her workers, don't bother to check registrations on Minnesota witnesses, she's correct, at least 96% of the time. But here, when we look at any specific ballot with a Minnesota witness, when we come in here, we know, based on the experience in this state, based on the diligence of Carver County, that 96 times out of 100, that person will be a registered Minnesota voter. Again, I make the assumption that people's intelligence and conduct is pretty much the same from county to county. I made that assumption in my opening statement. I have not heard anybody that has the audacity to disagree with me and say there are smart counties and dumb counties. I suggest the first person to do that will probably not run for office. So the witness satisfies the standard by having a Minnesota residence. That satisfies whatever test without checking. And if somebody alleges to the contrary, as was done in a number of cases, and proves to the contrary, based on some suspicion or based on some diligent checking, and can prove that that person is not a registered Minnesota voter, then under this court's strict compliance standard, out they go. But there being proof neither way, the mere fact of the Minnesota address with the witness stands for the proposition that we have proved it's more likely than not that they are registered. What about missing applications? That got to be quite a bugaboo, and I suppose maybe even in a trial like this, a little humor is occasionally called for, as I asked Ms. Engdahl whether or not she was aware of anybody in black clothes sneaking about the Plymouth City Hall looking to steal ballots that they could, for some reason, sell to somebody. There's a presumption here. You can't get, for the most part, an application. You can't get a ballot without sending in an application. There are one or two instances, apparently, where husbands gave them to wives, where it happened. But you can't extrapolate from the exception and make it the rule. 99.58 whatever percent of people that send in absentee ballots got them by sending in an application. There's no evidence to the contrary. So when the application can't be found, and we do have evidence in this case that counties and precincts lose applications, it is more likely than not, whether it's there or not, that there was an application and the person did conform their conduct to the law. To ask us to prove that which is presumed statistically is to ask us to prove things to a certainty. But we're one to take 10,000 absentee ballots. In over apparently 9,995 of them, the people sent an application in. It's proved by virtue of the fact itself, by virtue of the ownership of the ballot and sending it in. Again, if you don't do that, the exception will have gobbled the rule. Let's look at another issue. And if somebody says you didn't send in an application, the naysayer should have to prove it, because virtually all the time they did. Why would we kick people out who almost to a moral certainty or an absolute certainty had to have sent an application in, or they wouldn't have a ballot? Let me go to this signature mismatch issue. The testimony of voter after voter has been that they signed both the application and the envelope. Mr. Amara is the poster child for this. There is not a semblance of similarity between his two signatures. Yet, somebody looked at it and said, that's not their genuine signature. You can't do that. If it's anything that the testimony of the voters that the contestees brought in, if there's anything to be gleaned from that, it's that you can't look at that and make that determination. If you haven't got a reason to believe that that's not the genuine signature on the of the voter on the envelope, then no one has a right to kick that ballot out. Because Ms. Engdahl in Plymouth kicked out 75 of them in Plymouth. With all due respect, that's like reading tea leaves. There is no scientific basis for doing it, and it should never be done. There's an assumption of correctness in Minnesota citizenry. There's a presumption, absent evidence to the contrary, that people do what they're supposed to do. And there's a presumption of validity that runs throughout the law that is applicable to those ballot envelopes that they were in fact signed with the genuine signature of the voter whose ballot is within. Let me raise another issue about these applications. We briefed this issue some time ago, and that is that as long as it's the valid, genuine signature of the voter on the envelope, it really doesn't matter that they gave authority to their mother to request the ballot. This is a fraud protection device. People don't get ballots for other people without the voter being involved. There's no fraudulent desire on anybody's part here. Maybe in a town like Chicago, people do vote other people's ballots. I don't know. But there is no reason to believe when a college student says, "Mom, would you get me an absentee ballot? It's okay, sign my name." Is this the only place in the law that authority to sign your name doesn't work? I can ask a person to sign a check for me. I can tell them write my name on a check. They have all the authority in the world to do it, as long as they don't abuse it. But again, there's a presumption of regularity. There's a presumption absent evidence to the contrary, that the signature on the ballot envelope is the genuine signature of the voter. There are 1,360 ballots that are sufficiently proved up if we make common sense assumptions about what's in front of us that should be opened and counted. And if we apply the standard of a preponderance of the evidence, which is the legal standard that applies to this case. Now we need to talk about some serious constitutional problems that this court has looked at and appears to find inapposite. I never fail to believe that when I'm talking to a jury, even if they have their minds made up, I might get them to step back, clear their minds, and open their minds, and let me try to convince them to the contrary. It's more difficult with judges to do that, because basically you know more about the law than I do. But I need to take this opportunity to go back and discuss some of the issues that I discussed in my opening statement that you have allowed us to make offers of proof on. But I believe there is substantial and sufficient evidence in the record as it exists without the offers of proof for you to deal with these issues in a way that you have not wanted to. Yesterday, Mr. Lillehog called me a name. I thought he called me disingenuous, and trial lawyers call each other that all the time. It's no longer an insult. However, upon further review, I found out he called me ingenuous. Well, he's from Harvard and I'm from North Carolina, and I don't know what that means. So I asked some help from their side. Apparently, it means candid, frank, guileless. They grew to love him because of his sincere and ingenuous nature. I take it as a compliment. And I'll try to be that way when I discuss the issues that I want to raise to you. concerning basic systemic problems and constitutional issues. I'll do it without guile or sophistication, and I'll tell you frankly, I submit that you're wrong. First of all, we have a violation of due process. Why? All you have to do is read Roe against Alabama. You can't change the rules after the game is played. Under Roe against Alabama, the 11th Circuit, when Alabama decided during a post-vote litigation that they were going to start recognizing, at that time, unwitnessed ballots, the federal court looked at the doctrine of abstention, looked at the Anti-Injunction Act, and says, this is a constitution that we're talking about. We will not abstain. We will not be restricted by the Anti-Injunction Act. We need to stop this, because when you change the rules after the game is played, you violate due process of law by putting a state in a situation where they apply two different standards at two different times. And that's not an equal protection issue. It's a due process issue. The game was played and was over on Election Day. The polls were closed and the ballots began to be open. There were rules in force that day, and absentee ballots were counted around this state pursuant to those rules. 90% or 95% of the counties allowed ballots to be open and counted where there were unregistered witnesses. Many counties, and Minneapolis, did not signature match. You can tell, because in Minneapolis, when Ms. Reichert's testimony was done, there were 5 signature matches left in Minneapolis. Plymouth had 75. The logical conclusion to be drawn is Minneapolis, the biggest city in the state, didn't match signatures, while Plymouth did, and for the most part, with different degrees of scrutiny, so did the rest of the state. You also heard Mr. Mansky's standard: do everything you can to enfranchise voters. Plymouth is the poster example of doing it the other way. You saw Mr. Mansky on the stand yesterday and the day before look at those signatures and look for any conceivable similarity in them so he could let them in, not kick them out. Minneapolis didn't match signatures, but we are now. Your February 13th order requires signature matching. Your February 13th order requires that witnesses be registered. We found some other problems that seem to change with people moving apartments, where Hennepin County applies one rule and then other counties apply another. But the important thing is there were rules on Election Day, and they are desperately different from the rules you're applying, because you're looking at the statute, and on Election Day, many counties didn't. When you cast this whole new set of rules and determine that ballots within certain categories were illegal and couldn't be counted, it's a pro tanto finding that there are thousands of illegal ballots already in the count. So if that's true, the rules were changed, after the game was played. There's another problem with that issue. If in fact, and I will deal with the Bell against Ganaway issue in a minute, but if your February 13th order remains extant, there are several thousand votes you've called illegal by your standards that are already in the count. That being true, there's no way to determine who got the most legally cast votes because those are illegally cast votes. What's the math? If 4% of the ballots in Carver have unregistered witnesses, and we know that to be true, it must be close in Minneapolis. Carver had 48, let's say 5,000 ballots. Minneapolis has 17,000. 3 times 5 is 15. That means that there must be somewhere between 600 and 700 ballots in Minneapolis with unregistered witnesses that have already been counted. Ramsey County has about the same number of ballots as the city of Minneapolis. That's another 600 or 700. St. Louis County brings it up to about 2,000, and I haven't discussed the rest of the state because virtually nobody but Carver, Lyon, and a couple other counties check for witness registrations. Those are, according to your February 13th order, illegal ballots. They are in the count already, and they can't be removed. This changing standard from one time to another is a substantive due process problem that cannot be corrected unless the standards are made the same going forward as they were in the past. Roe against Alabama tells us that. The remedy, as we've propounded from day one, is to apply a uniform standard on opening ballots now that it's consistent with the rules that were in place when the game started. We've made that proposal by offering about 4,800 ballots originally. The changing standards from time to time is a due process violation. Equal protection is another issue. The problem here is that whether you got your vote counted on election day varies depending upon where you live. I can give you the Plymouth against Minneapolis example again on signature matching. I can give you the voter registration issue again from Carver to virtually every other county. This isn't just a problem of subjectivity, it's a completely different standard from county to county. Lord, only Hennepin County and apparently every subdivision takes your franchise away if you move to the apartment next door without re-registering. Only Hennepin County apparently plays the hyphen game. If you pick one up or drop one off, you lose your registration. They don't do that in the rest of the state, as far as we know. Some counties don't reject any absentee ballots, as we showed you as this case began. Some reject as high as 12.8%. But we had to get to the specific reasons in order to make our case, and we have. Let me get to the database issue. First of all, I got called to task for something I said in chambers, which isn't really cricket, and I was meticulous not to use the terms that Mr. Hamilton accurately quoted me saying in public. So I'm not going to repeat them here. That's out of deference to the Secretary of State and how hard they work to do the best job they can. But 1 week ago, now 9 days ago, the Secretary of State's database on registrations had not had input of data from 600 precincts out of the 4,000 in the state. And I'm not talking about the DVS new licenses. I'm talking, according to the testimony, about the input from the November election. They didn't have it from 600 precincts a week ago. Suggest to you that they didn't have it from almost anybody on January 26th when we started this trial. We went first. And now it's down to where there's 36 precincts missing. This, I don't want to call it organic, is a dynamic database that changes on a day-to-day basis and will come to rest sometime in the next week. Then the data will be input and the database will presumptively be correct. With a 2-day lapse, Mr. Mansky found apparently 5 changes in the database that changed the status of voters. There can't be any more compelling evidence that we were dealing with a constantly changing database. And we went first, so it was certainly a more mature and more complete database when the contestee finished their case. Mr. Lillehog, during his examination of a number of people, would say, this is your status, active, registered here, and then would say, and let's cross-check it to be sure we're right with the election history, if you remember that testimony. Well, that shows 11-4, you voted absentee, that's a cross-check. Well, we found out yesterday from the technology department at the Secretary of State's office that it isn't a cross-check, that the one data stroke enters both the voter lookup and the election history. So it's not a cross-check. If there's an error in one, it is highly likely there will be an error in the other because they're not entered independent. They don't check each other. You can't really check the registration status of people until you use the most up-to-date, and I suspect within the next week, the final data access. But remember, it's our position that there's a presumption of regularity and that when you assume people are registered, they are. Let me talk about Bell against Ganaway, because that's been visited upon us by the court as a substantial problem. First of all, it has been argued that Bell against Ganaway stands for the proposition that somebody challenging an absentee ballot is a stop to do it after the ballot has been tabulated, because they gave up their opportunity to challenge it. That's the square holding of Bell against Ganaway. We produced irrefutable evidence in this case, really not even subject to cross-examination, from Ms. Reichert, from Mr. Poser, from Mr. Gelman, and from Mr. Mansky. You can't challenge absentee ballots in this day and age. There's no opportunity to do it. Challengers stand in a segregated place, and the only thing they can challenge is the voter's eligibility, like that busload of people that just came in, they're not from here. Or I know that guy doesn't live there because there's no such address. That's what a challenger is. Now, realize Bell against Ganaway was 33 years ago and really doesn't get cited anyplace. And also realize the query that's essentially inherent in the case of how could you do this on a statewide basis. But even more important, look at the justices that dissented based on carrying this type of holding forward. Mr. Chief Justice Sharon, Justice McLaughlin, and Justice Otis. But it doesn't matter, because the evidence from the Secretary of State's training manual, from each one of the auditor's training manuals that's in evidence, from Mr. Mansky, from Ms. Reichert, and anybody else I might have asked, is challengers have nothing to do in this day and age with absentee ballots. And so to argue the estoppel issue that arises in Bell against Ganaway as stopping us from attacking the legality or illegality of the ballots that were counted on Election Day, or as I've said before, to use them as a control, is the misuse of the case. It isn't very good law to begin with, based on the dissent. It hangs on a very slim reed, and it's completely inapplicable to the case before you. All the justices, including the majority, knew that try to apply this thing to a statewide election and you've got trouble. And now we know it's physically impossible. You can't be stopped by conduct that's physically impossible to go through with. There are 1,630 ballots in evidence. If the proper presumptions are applied to them, they will be opened and counted. I'm not nearly as confident as Mr. Hamilton, who apparently, when he says you open their 250 and Mr. Franken's going to win, I don't know who are inside ours, but there's about 1,650. They ought to be open, they ought to be counted, because we presume here that Minnesota people follow the law and the presumptions all work in our favor. They're more likely than not, upon further examination, to conform to the statute. Rule 9 is invalid. We pick up 61 votes. The 133 and the others can't be counted because they don't exist. And then there's the issue of the 413 ballots, now reduced to about 275 that are out there that even the county officials thought were improperly rejected. And the Supreme Court order over two dissents brought the political game to bear on those ballots. They should be open and counted. And I don't know who those people voted for either. I have a list of presumptions that are reasonable, legal, and correct. If a voter got a registered voter envelope, you should presume he was registered, unless you have evidence to the contrary. If a witness has a Minnesota address, presume they're registered in Minnesota, because 96% of them are. If a voter received an absentee ballot, presume he or she applied for it. How else would they get it? If a person signed the application or ballot, presume it's their genuine signature, absent evidence to the contrary. And by the way, Ms. Kecker didn't try to vote twice. Ms. Kecker thought that her absentee ballot might not have been counted or about to be counted. She went down, spoke to the election judge, and found out through the system that there weren't going to be 2 votes, and there weren't 2 votes. That's another presumption. It would, to make us prove that people didn't vote twice, there isn't any evidence that people voted twice. The system catches it. It's designed to do that, and the only way people do it is by accident. And we don't have any evidence of it happening in this case. If there's one thing you can rest assured of, is that nobody in this election voted twice. All of these presumptions are logical, they're common sense, and they result in compliance with even your 213 order. Let me kind of show you an example of what happens and where common sense goes out the window when you don't presume what's logical. Yesterday, Mr. Mansky's on the stand. And we got into this business of the definitive way to prove that if somebody voted or didn't vote is with a roster. And so I said, Mr. Mansky, did you check the rosters? Well, no, actually I didn't. Okay, I guess you can't make a definitive answer to that question, but wait a minute. You had 2 trained workers and you said, go get me the rosters if they're there. And they never came back. We presume that those well-trained people working for the best expert in this state went out, couldn't find them, so they didn't bring them. You can't presume that they went to lunch or went out and started drinking martinis and didn't do their job, or that they found them and decided to hide them from Mr. Mansky. Those are absurd assumptions to make. You make the same assumptions in law that you make as you go through life. You assume the logical. You draw common sense conclusions. The common sense conclusion was that they didn't sign rosters. There wasn't any evidence of it. I thank you very much for the tolerance. There is no question that I stumbled and stammered a lot in the course of this case. I now know a lot more about election law than when I started, which was 0. You have been generous with your time, and I thank you very much. It was a pleasure.
Thank you. Thank you very much. That'll be all for today.
If I might. The court has given us a deadline with respect to certifications, and that deadline passed during Mr. Friedberg's argument. I've consulted with Mr. Friedberg and with the clerk, and I understand we may make that submission. How would the court like us to do that?
We have some other matters that need to be addressed in regard to scheduling with your proposed findings, so we will see the trial counsel in chambers in just a few minutes.
Thank you, Your Honor.
Thank you.